I request Ravi sir to introduce today's speaker.
Yeah, good morning, everyone. Today it's my privilege to introduce a very highly successful speaker, Mr. Panicker. He's practicing advocacy now in the areas of insolvency and many other things. He's also a qualified insolvency professional, and he's a member of CMA Institute, and also he is a member of CMA Institute of other countries too. He had a stint with the HDFC Bank, and then he moved on, and he was also a chairman and chairman for Southern India Region of Cost and Management Accountants. Uh, he is been chairman of many things in his administrative capacity. SIRC, he has been there. He is there in the Board of Studies and School of Legal Studies, Cochin University. He's been a chairman of Kerala Insolvency Professional Forums. He's also a certified professional in commercial arbitration from the Institute of Arbitration and Mediation. And he's also a member of Institute of Management Accountants of USA, Sri Lanka, and also he graduated from legal law school from Cochin University, and he's got a lot of other credentials, and today he's going to help us understand the litigacies of valuation in terms of litigations. Over to you, sir.
Thank you. Thank you so much, my dear beloved friend Ravi. And I thank Sri Ravi Chandran also. We at times call it meetings. I thanks the organizers, Vijaya ma'am, and I was wondering, when I was invited to look at the timing, 7:30, I was so happy that a morning well spent, well begun. It also gives me a feeling that it's like a deja vu. When we used to write examination for CA, those days examination starts at 8 o'clock, 8 to 11. And we used to run from our home to be in the examination center. So somewhat similar, I have a feeling of writing an examination before very elite friends of mine who have the joint wisdom would be immeasurable. Because every time I fondly remember the meeting which PA had with our institute, Cochin chapter of our Institute of Cost Accountants of India. Oh my God, such a lot of insights. So thank you so much for inviting me. I feel that more than you people, I have learned. I've researched a bit on these subjects, and I thought I reaffirm that those people who have passed these valuation examinations should have reasonably deep knowledge, in-depth knowledge on the business, the valuation methodology, extreme level of common sense, understanding the business actually more than anything, and the sense of applying which method based on the facts on ground. So when I was going through this few judgments, the common factor which I thought was the judiciary rarely interferes in a matter of expert's wisdom. When an expert has applied his mind appropriately with the information given to him based on the circumstances in which he has been assigned, or the background which has been assigned to him, normally, in only one case, I could find out that the learned judicial member, learned judiciary, the particular forum, had a difference of opinion with the expert. So what does that essentially mean? It means that valuation is an estimate. Valuation expects some sort of deep understanding of the business, not just share projections and also understanding as to for whom, what is the real purpose for doing this assignment. So with that, with a small intro, I'll try to start the topic, and let me just share my presentation first. Yeah. Is it visible, friends?
Yes, sir. It's
All right.
visible.
All right. So I was just going through what are the scope of this profession. Scope of the profession in the sense, even though I understand my learned friends are, all of us are, all of you are, I've not qualified this RV exam, though I registered myself. I didn't get the undivided attention. I couldn't give undivided attention and spend some time on it. Basically, even though we are IBBI registered valuers, but the scope of this profession is high, very high. So I'm relating this with the IBC and also the Companies Act liquidation provision, wherein when a company is undergoing or admitted to liquidation under Section 271, the services of insolvency professional is taken by the tribunal. And consequently, the appointed insolvency professional would perform the job of a provisional liquidator and a company liquidator thereafter. He will chair the he will chair the committee of which is termed as winding up committee, wherein one of the members would be official liquidator attached to a particular high court. And of course, there is another person who will be a professional who is supposed to render service or expertise to that committee. Likewise, I feel that probably the registered valuer as of now may not be under IBBI or all those RVOs, may not be may not have stretched to those enactments, but sooner or later the services of RVO will registered valuers will be stretched to that areas as well, because end of the day there are three types of assets, which is plant and machinery, land and building, and SFA. And all those, when it comes to an organization, all these three aspects are part and parcel. And for an individual, yes, there will be a little bit of difference. But then, friends, let us just quickly go through the various laws wherein the assets are being given significance. Whenever there is a significance given on assets, the role of a valuer will also, it's coextensive. So we used to say every law will have a foundation on the Constitution of India. Insofar as valuation goes, Constitution of India, Article 19 and 31 very clearly says, as a person, all citizens, be it company or anyone, right to acquire, hold, and dispose the property. So when it comes to acquiring the assets or even holding, when it comes to valuation or the disposal, valuation is important. Article 31, no person shall be deprived of his property. Article 21, I'm sorry, it's not 31, 21, authority of law. So therefore, there has to be a process laid down. So therefore, part of that Article 21, it's not 31, Article 21, valuation gains legal support. Of course, when it comes to contract, we have be it a mercantile law or a commercial law, this gains huge significance, because end of the day, when we are purchasing or acquiring the shares of a company, or if you're a minority or a merger, acquisition, or demergers, or even other corporate actions under contract and companies act together, this is going to be having a huge impact or a great scope. Easements Act 1882 and relate to the easement. Again, the easement, there are certain rights. Any customary right in and over immovable property by anyone may possess irrespective of irrespective of other immovable property. All types for limited time or on condition restrictive and certain rights and license. Friends, what happens here is, what happens here is when it comes to Competition Act, the endeavor is to settle or come to a conclusion wherein valuer or a professional like a chartered accountant or cost accountant or a company secretary will have to play a big role, and their expertise clubbed with valuation so that some value has to be arrived. For example, formulation. All those things require some sort of valuers interference or the company's investments interference. So this is going to be an extremely, extremely important profession going forward when things are to be more of a objective way of decision rather than subjective. So Indian Evidence Act also shows about certain provisions where you need to show some documentary uh, materials for coming to a conclusion. So therefore, there also this profession picks up. Earlier law, British law, government grants. So government used to, there will be assigning of government-owned lands for a specific purpose, and that which requires some sort of, again the I'm sorry, I'm sorry. Yeah, government certain valuation is required. Of course, succession, all of us know when it comes to an individual or assets of an individual, personal law, succession law, all those things is going to have a huge impact, friends, when it going through um, valuation going forward. These are the areas which, according to us, probably we feel that, okay, we have not ventured into, but then these are all futuristic things which I'm trying to say. So as a very responsible and respectable organization, we, BVO, along with other RVOs, ought to take it up with the regulators, the framers of the law or the executive, and ensure that some sort of professionalism is brought into it. All of us know what was happening when it comes to valuation of a company in the instance of bank lending or bank providing assistance to a borrower. It's sort of such a subjectivity used to happen. And nowadays, that subjectivity is getting exposed. Why? When a company loan is being given to a borrower, thereafter, assuming the default happens, and and the lender prefers to refer it to the NCLT under Section 7 of IBC. Thereafter, your valuable services are being invited. You find that that value doesn't happen. You understand that the value at which the loan has been extended on the assets is nowhere there. And there it starts. Now the members of the COC protests. Look, this is not the value, this is another value, and there starts a trouble, a headache for the learned RP. So therefore, my friends, I feel that um, all efforts should be taken to extend the services of a valuer, be it plant and machinery, land and building, and SFA, to the other areas, especially through lending. Before, I'm not talking about IBC or CB Companies Act alone. I'm talking about other areas also. How and when and how to, where to trigger this. It should be a joint wisdom, and definitely some sort of dialogue has to happen. It is going to benefit our economy. Again, friends, when it comes to limitation also, uh, there's a huge impact of Limitation Act on the valuation, according to me, because assuming the agreement is barred by limitation, how will you incorporate that in the valuation. Because when it comes to a suit, 12 years time, there is something called adverse possession. All those things, well, how will you inculcate all those things? How you are going to appreciate all those legal aspects in your valuation? Or how will you document it? While going through certain judgments for this presentation, that's why I said I'll be profusely thanking all of you for inviting me. Otherwise, I could have left my attention. A lot of importance have been given by the judiciary, the way in which a valuer has kept his records. And it was produced before the court, and court was convinced, and they stood as a rock with the valuer. So that is the importance of the thought process. That is the importance of documenting it. That is the importance of recognition from the judiciary. And in comes our Transfer of Property Act, supposed to be one of the most complicated act ever we have, we have formed as a country, as a republic. So under Section 37 of the TP Act, set of definitions have been elaborated at transfer of movable, immovable, sale, mortgage, land, exchange, gift, actionable claims outlining the corporeal and incorporeal ownership, bundles of rights, ownership forms. See, bundle of rights comes with some sort of valuation, especially when it comes to intangible assets. I will never ever venture into such area because I'm not expert in that area. All little is I'll be a very good student if somebody can teach me that. But end of the day, projections based on past performance, near to reality, with a good discounting factor, appropriate discounting factor, not good, appropriate discounting factor would save your skin, friends. That is what with that I will stop, because application of mind is appreciated at judicial levels when it comes to adjudicating authority or any courts, constitutional courts or be it tribunals. Application of mind and in-depth analysis, whether you get time for all those things, whether you get documents for coming to a conclusion, it is up to us, or it is our how strong we are in our um, assertions is something which we have to be careful. And of course, for the valuation, stamp duty levy and other things, this is going to be an extremely important. Registration Act, I need in overemphasize. Land Acquisition Act also, I need in emphasize. All those things, friends, end of the day, this is supposed to be having a huge impact on the valuation. Fair value, which we don't know how, all we know is a value assigned by the government, an executive, and a particular based on a based on a survey number. So with beyond below which we cannot register. So all those things are extremely important, and we have to have a. I feel that being a valuer, it is an extreme because the concept of valuation gives importance to your estimation. Your estimation is a function of how you are aware of the law of the land. Law of the land expects us to be fully compliant. So therefore, if that is having a mismatch with our understanding and our estimation, then it's going to be a big problem. But there are certain judgments which would be of help to the valuers or experts. But then the basic thing is whether we have complied with the basic knowledge. I'll explain to you one case later, if time permits, where I was flabbergasted with the way judiciary has supported RP and RV. Okay, let's just quickly go through that. I got a little bit more presentations to come. So RERA Act also protect the home buyers as well as help the real estate industry in boosting investments. Now, this is a very, very important enactment according to me. This has been a ray of hope for home buyers. I was wondering how this particular industry was literally taking the home buyers for a ride without any control, clubbing all those things. All those revenues were, all those collections were from the poor home buyers were deposited in one account. You take everything with whatever you don't have any control as to for what purpose money is being withdrawn from that account. All that has come to an end with the RERA. Kudos to those states who have implemented it, and could and more is expected from that particular act. I mean, end of the day, all these poor home buyers are, as all of you know, unsecured financial creditors. The evolution of IBC itself says that they've put into a separate chair initially. Other creditors, I forgot the name they used, other financial creditor or something like that. And thereafter, they've been recognized, rightly so. Again, slums areas improvement and clearance act, all those areas, this is going to have huge impact to all my friends out there, where you have a huge governmental action is expected. All of us know how Adani Group has taken initiative to develop the slums of Mumbai. So this is going to be another area where all of us can, focus on and bring to the knowledge of the regulator of a particular state, or a government of a particular state, so that contribution, your recognition, and the co-value creation, or the balancing the interest of all the people, all those things. And when it comes to us, objectivity is going to be the order of the day. So rather than subjectivity, friends, relatives, cousins, cushions, and all those things will wither away sooner or later. But the professional service of a RV, or a valuer who has gone through the rigor of the examinations of IBBA is going to be recognized sooner or later in other enactments also. And I would strongly urge my friends to engage with the regulator, because I'm yet to see an occasion where the regulator simply wishes, push you away when it comes to a very, very decent proposal. Environment Protection Act also, friends, this is going to be having a huge impact on the the society. Therefore, there also, any solid decisions to be taken has to be with the forest conservation, provide the conservation of the forest and the matter connected there in ancillary and incidental there too. Look at the way ancillary and incidental, that itself means a lot of huge area. Assuming somebody is going to start certain initiative there, this is also going to have an impact according to me. Property tax, Benami, FEMA is another area where all of us can create a lot of value, because when it comes to FEMA and income tax, valuation is an area where regulators very, very commonly use the services. Factories Act and Special Economic Zone, codes of municipal laws, all those things are areas where we can come up with opinions and be intellectual partner. All of us know about this particular, our great RDD BFI, SARFIC, and income tax, premium section 55, rule 11, all those things we know. Premium valuation issue with a huge premium, and this is under this act, a lot of notices were sent those days, and the valuation taken by an AO, valuation taken by the assessment done by a assessing officer, normally supported by Commissioner of Income Tax, and thereafter ITAT or even the Honorable High Court interferes and say that, look, this is vindictive towards an assessee. All those things are there. So income tax obviously is going to be a huge area. I'm not sure whether they have allowed you as a subject to confirmation. I think I don't think RV have entered into the mind space of solidity. And Companies Act, all of us know, 62, 177, and 192, valuation, all those things. We will these two acts are currently more into our focus now. Mergers and acquisitions, mergers and amalgamation is an area where, uh, friends, the services of SFA is more often used, and every time somebody will be aggrieved. And here is an area where I said we should have proper documentation, application of mind, and also, uh, according to me, if possible, I don't know whether it's possible, but then definitely possible though, to have an engagement discussion or a meeting, and understanding the way the other valuers. I'm talking about if SFA is giving the final output, he need to have a discussion with other valuers also, because end of the day, this is going to be challenged, or 90% challenge can definitely challenge on the valuation can pick up. Need not necessarily you are the trigger, your numbers are the trigger, but fact of the matter is it could be because of the operation mismanagement, minority, majority, all those particular gentlemen. And I was going through certain judgment. Basically, I'm not talking about major corporates like Infosys or even HLL or Tatas. I'm talking about small companies. They are quasi partnership. Suddenly they become a big company, huge revenues. Suddenly this pops up. So they, whenever they want to for example, in the NCLT Kochi, there was a merger of about 36 companies in one stroke. So all those things can expect certain, judicial scrutiny. And there is an opportunity for, this is an opportunity to gain more knowledge, and based on certain judgments, and of course, uh, understanding the business. So to simply put, the valuer is not just an expert, he's definitely an expert to know the expert in his respective field. It doesn't stop with that. It expects it, the law expects you to have an understanding of the business. So therefore, you have to corroborate documents with other, what little I could gather from the judgments is we should corroborate with other documents available, and also the company's expectation. It's not just a dragging of cells of an Excel sheet and coming to a projection. And there are other important stakeholders. For example, before taking up certain assignments, I'm sure all of us do, but then for the sake of repetition, for to convince myself, before taking up certain expectation, we need to understand the background in which the assignment is given, or the other stakeholders. For example, if there are minorities, whether there is other bankers, how are they looking into this entire decision? Major investors, how they are going to do this? What is there any is, you need to get certain, I'm using the word informal discussion also with co-professionals, also the management, to understand, so that your decisions are on the right track. And insolvency bankruptcy code, according to me, these two particular acts have been the trigger for the development, the quick development, the strong development, the objective development of this profession. I was wondering, um, um, how IBC made a change in the economy. What would have been the Indian economy if we never had IBC? Because all of us know we are talking about resolution of insolvency rather than recovery. Assuming the dirty dozen another foray of companies or corporate debtors were not resolved. Their insolvency is not resolved. Our banking system would have been gone for a toss, as I mentioned 5 minutes before, as to how the lenders used to rent. A lender used to give money to a borrower who will just sign on all the documents. And in the probably IBC is the only act which is um which is uh, pronounced, which is notified, which talks about how the money has been spent by the entrepreneurs or the directors when they were in power, which led to this insolvency position. And thereby how to get the money back under section 43, 45, 49, 50, 66, etc., etc. So all those things, when it comes to an avoidance transaction also, um the report of valuation is going to be referred, or at least the reason how it has been company has taken a hit of poor management. So we all know during the CARP the valuation is taken. Why? To have an understanding of the value of the company so that somebody comes with taking over. Look at the national interest they're looking into. Previous law was all recovery. So here we are looking at somebody look an asset. It was some 100x. Now it is only 50. But would you be interested? That is the thing. And again, Section 33 liquidation also. Again, the RP has the flexibility to adopt the valuation during CARP, or he can even apply. Now, what happens? All of us know. Probably we only know that we more focus on 180 days or 90 additional days or even 30, 60 additional days on extreme other cases in extreme unexpected event, assuming it is going further. Only one valuation is required. Only one valuation is required. Or else there should be some sort of major salient event which has happened, which prompted another valuation by the CA during the CARP. Otherwise, it is only one valuation. I have to check other cases also, but I've never seen, unless there is a dispute, unless there is a delay, multiple valuations being taken during the CARP. I may have to see. But when it comes to liquidation, even though the act says 1 year, there are instances where it stretches to more than 1 year. And it gives an leverage for the learner liquidator to go for another round of liquidation. In my case, in couple of cases, I mean, about few cases where I have acted as RP, thereafter as a liquidator, I have convinced the stakeholders committee, consultation committee, as to look, this was taken through 2 years before, 3 years before. Now we need to do something. We need to approach the honorable tribunal for a revision, because nobody is picking up this property because of a uniqueness of this particular property. So when I went again with a liquidation, I mean valuation during the liquidation, and we also know that if the value is not fetching 25%, 10%, and all those things, you can reduce it. So when it comes to reduction during the liquidation period, reduction the value, liquidation value during the liquidation process, I strongly feel that a documentation is going to be extremely handy. And of course, it has to create value also, in the sense there is no point in not having patience, not looking into areas to sell this, or if it is a piecemeal sale basis during the during the IBC, we have to have some sort of decision, application of mind as to look, we'll go for another round of liquidation. Otherwise, simply by reducing may not give the appropriate value to the stakeholders during liquidation. 59 is voluntary liquidation, friends. Same thing. Only thing is the difference between liquidation and voluntary liquidation is declaration of solvency. Declaration of solvency essentially says that company's assets is more than liability, and the intention is not to defraud the creditors. Therefore, when you say that you don't intend to defraud the creditors, then there should be an objective valuation, objective assessment of things, wherein um, and experts valuation is certification is required. So this is the area. So these are the areas according to me which are the laws which require some sort of um, indulgence from the valuers fraternity. Maybe this is the only screen. These particular slides is something which you rightly venture into, but then there are huge scope when it comes to your thing. And for a negotiation or arbitration and mediation also, friends, um, that is picking up in a big way, arbitration. And now I'm sure all of us know, then even the name of the Arbitration Conciliation Act is going to be changed to just become an Arbitration Act. Now that Mediation Act has come, it's going to be an Arbitration Act and another law called Mediation Act. So all those things, according to me, I'm so bullish about this profession, not just for the sake of saying this during a presentation to a learned crowd here. This is going to be the order of the day because experts, you are an expert. So I'll quickly go. I think what is the time now? Yeah, I'll try to quickly flip through these presentations. Alok Kaushik and Bhuvaneshwari Ramanathan, the Supreme Court judgment, wherein RV does assignment. He later on NCLT sets aside. I mean, NCLT admits, and thereafter NCLAT sets aside the uh, admission. Therefore, he was not paid, and RP, after putting it back to NCLAT, say NCLT to decide on this. Typically, it happens like that. Why? NCLAT do not decide because NCLAT is an appellate court, not an adjudicating authority. They normally 99.9% they put it back to NCLT. In one of the case where I've argued before Honorable NCLAT, NCLAT says you go back to NCLT and come out with a secure. It's not for me. I was arguing for a learned professional, learned RP. Thereafter, RV in this case agreed. RV, poor RV. Normally RVs, let me all of us know, the luxury of sharing information, sharing thoughts with this crowd is all of us are in the equal footing. So all of us know our pain. If you ask me, RV or RP gets fees faster, timely. I would say first among equals is RV. RV gets faster or earlier than RP. So here, this poor gentleman RV says, I'm ready to a reduction of about Arochare. Anyway, it is remanded back and set aside. The order was set aside. So I'm ready to give you a small discount of, I'm sorry, I'm using the word discount. But anyway, I'll reduce my fees. But again, what happens is RP pays a certain sum. But what happens is NCLT dismissed the application, concluding that it has been rendered functus officio. NCLT rejects saying certain sum has been paid. So what was the issue? Issue was in whether NCLT can decide on the fees of RV in a case where CRP was set aside by NCLT on the ground that RV was functus officio. Look at the way, friends. Yes, it says, though CRP was set aside later, the claim of the appellant as RV relate to the period when he was discharging function as an RV, appointed as an incident of the CRP, and hence NCLT would have been justified in exercising the jurisdiction. Therefore, NCLT has the power according to Supreme Court says, look, NCLT is an adjudicating authority. Under 60 subsection 5, it has got the authority. So therefore, don't be don't have a feeling that though NCLT will assign bit. Initially, normally what happens is NCLT takes a very unbiased view, saying that look, when it comes to fees, you please decide, discuss in the committee of creditors, or you discuss with the directors, you discuss with somebody and come back with an affidavit or a memo. We will work on that. If that is not happening, what is going to happen? I'll give you a classic example of a case where a poor RP, and why I'm using the word poor means a very elderly person. It is one of the earliest cases of IBC in NCLT Kochi, and
हालत खराब हो गया ना
I'll proceed with that.
कल आने वाले हो कि कल मिस करोगे
Yeah. Can you please mute, friends?
Vijaya, can you mute him?
ट्रैफिक का
I thought it'll be a question. That's the issue. It's not that I can't speak, but then I'll stop it based getting a feeling that it's
apologies
a
it got
question.
unmuted accidentally sorry
No problem. I can talk. We also do this mistake when it comes to online hearing. Don't worry.
sorry
So Prashant sir says, no, sir, my fees for few assignments are pending 2 to 3 years. I'll give you a shortcut. I'll give you after this. Don't worry. With you. So friends, here what happens is that gentleman, very elderly person, I don't think he can take up assignments anymore because I'm sure he has closed 70 years. There was no assets in the company. It was forced to be closed down. And suddenly he didn't even get one pie. Believe me, not even a rupee. Andhra Bank it was. Got merged with Canara Bank. And the suspended managing director just vanished. I understand that he's making a lot of money in some other business nowadays. In fact, he came to me for some advice. That's why I'm saying that he's doing really well nowadays. These are all typical, Gochi people. You know what happened? Please hear me carefully. We as a professional, especially RP and RV, are we cannot the members of NCLT, with those extreme respects to them, are predictably unpredictable. Predictably unpredictable. Earlier members said, no, what you were doing, you were sleeping, and all the was shouting at my learned friend. I mean, I don't know him, but I have to definitely say he's a very senior guy. I full respects to him. And he was so dejected. And we never knew, but suddenly my friend, another lawyer in NCLT, somehow got a reference from him, and he appeared. Then my friend, co-lawyer, we discussed this matter in the lobby of NCLT. Then I said, why don't you take it up under section 60 subsection 5, and also the trigger who has taken the decision for liquidation. Then it was committee of creditors. Then why don't you act against committee of creditors? So that triggered, suddenly the members changed, very, very empathetic members came. And now the position is NCLT is ready to, NCLT picked up Canara Bank, asked them to discuss. Now, how much should be claimed? That was a question. The question was answered like this. That is what, people are very, very, very interesting. A person who has never got any money during the CARP and liquidation, having got a lot of beating from earlier members of preceding benches of Kochi, suddenly understands that this particular bench is being very empathetic and sympathetic. Suddenly says, I need 29 lakhs as per the claims ratio, schedule 4. Then Canara Bank said, no, this is something which we never got it from a guy. Then learned members said, look, learned tribunal said, okay, you please discuss and get back. So I'm sure that at least he will get the money which he has spent. So that's a good thing. So NCLT is powerful, friends, according to Alok Kaushik case. Yeah. And Maharashtra seamless. This is a killer judgment. This is a killer judgment, friends. While after discussing this, I'll say how this case law has been misused. How this case law has been misused by a lot of lawyers. Maharashtra seamless SRA case. I mean, SRA, Maharashtra seamless was a SRA. Committee of creditors approved this. 2 registered values were initially appointed by the RP for determining the value of the corporate debtor. I'm just reading because this is a concise thing. I don't want to miss out any word. Their valuation were to tune of 681 crores and 513 respectively. Therefore, the third valuer pops up. They valued corporate debtor at 352 crores. Committee thereafter took into consideration the average of the closest estimates and 439. So where were we? 681, 513, 432. So 432 was this thing. However, the valuation redetermined to 597. So 681, 513, 352, average 432. Then again we redetermined to 597. NCLAT directs NCL to decide on the plan under section 31 of the IBC, approves the plan with 477 crores as upfront amount, plan value, and NCLT approved. Second round, NCLAT should increase upfront fees of four. So there was a discussion as to from 477 crores, you need to, put a little bit more. All those discussion happened. 597 has to be, brought in, paying additional of rupees 120 crores approximately to make it at par with the average liquidation value. So the discussion went into such a level that, look, upfront has to be in line with valuation. So that is the way things went on, and puts up a condition that if SRA increases the plan value by 120 within 20 crore, the plan would be approved or else rejected. So all those things, thinking up, and you should also understand that it was in the year 2019. The evolution of IBC just started those days, but then this was misused or used. So it reached up to Supreme Court. Supreme Court says, no provision in IBC says the plan should match with LV. So what did NCLAT says? If you pay another 120 within 120 crores within 30 days, done, or else go. I think I don't want to name the president of NCLAT those days. Valuation is an estimate to assist the COC to come to a conclusion. Our plan is passed by COC. Once the plan is passed by COC, the role of AA is to decide on 30 subsection 2 and 30 subsection 4. SRA cannot withdraw because once, SRA is not the appropriate person to invoke section 12A. SRA cannot do that. Only an applicant do section 12A withdrawal or proceedings under section, committee has to decide. Commercial wisdom prevails. So Supreme Court concludes like this: there is no breach of provision of IBC or the regulation thereunder. Upheld the order of adjudicating authority approving the plan. Valuation process prescribed under the IBC is to assist the COC to take decision on the resolution plan, and no provision and no provision in the IBC or the regulation therein lays down that the bid of the resolution applicant has to match with liquidation value arrived at in the manner provided under clause 35 insolvency IBB regulation. Friends, I'll take 2 minutes here. Extremely important. All of us are those who have passed IP examination or who have gone through that section 30 subsection 4. We know that under 30 subsection 4, you need to get 66% of 66% of the opinion, 66% of the voting of the COC, and you are done with that. But then what has happened was, in earlier days of IBC, almost all the company went into liquidation. So therefore, in 2019, they amended. What was the intention? Intention of the IBC, all of us know, is not for liquidation, for resolution of insolvency. Friends, the beauty of bow down to the wisdom of Justice Nariman, bow down to the way 30 subsection 4 has been drafted. 30 subsection 4, it contains a lot of, let me just see whether I can. Friends, I'll take 1 minute here to let you know what exactly secured creditor means. Secured under section 330. Why I'm saying this is RP has got a huge role. RP's valuation will have a huge role when it comes to passing of a resolution plan. My intention of taking 2 minutes in this particular section is to leave you some thoughts and also probably help you when it comes to an litigation or a discussion in the COC to approve it or not. Okay, you please note down the sections 330 and 331, 3 subclause 31 and 330. 330 says secured creditor means a creditor in favor of whom security interest is created. Very simple. So what is security interest? This is extremely important, friends. Security interest means right, title, or interest or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance. Or, see, till this time, it is fine. Because typically secure creditor, you have a mortgage, hypothecation, some sort of, and all those things fine. Look at the other, it is only in IBC. It's only in IBC. I'll just read the balance portion. Or any other agreement or arrangement securing payment or performance of an obligation of any person. So therefore, my humble submission to you, my friends, is whether when it comes to a sale agreement for sale between a home buyer and a builder, will it not be a security interest? When I push this matter to a lot of people, they thought I'm crazy. But there is a judgment of Honorable NCLT Mumbai. Learned member Saji Kumar has written this. Other secured creditors. Now please come to section 30, subsection 4. So therefore, what I'm trying to say is, under the IBC, when it comes to security interest, agreement for sale is also as good, because agreement for sale says, please pay this money to me. I will give you these scheduled payments. I will give you a construction. I will give you a completed construction thereafter. Then we will have a, sale agreement. Sorry, deed. Now, please come to section 30, subsection 4. Very, very important. This is extremely important, friends. I would want you to apply your mind. 30 subsection 2, and there are subclauses A, B, C, D, E. All of us know it's very, very important when it comes to passing of a resolution. And 30 subsection 2B says what to do with a dissenting financial creditor or an operational creditor. All of us know they have to be paid an amount, higher of the two, on priority. Higher of the dissenting financial creditor or operational creditor has to be paid on priority on an amount which is higher of either the resolution plan amount or value in the event of liquidation. Value in the event of liquidation, not about the liquidation value. Unfortunately, this classification has not been properly appraised by any of the judicial forum. What is, if you take any judgment, you say liquidation value, liquidation value. Liquidation value is not value in the event of liquidation. Value in the event of liquidation expects an application of mind. Value in the event of liquidation, look at the legality of the documents. Value in the event of liquidation expects how the other legal agreements between other stakeholders. So liquidation, according to me, liquidation value is not value in the event of liquidation. Therefore, when it comes to passing a resolution, the expectation, genuine expectation, the reasonable expectation is the committee should use the word apply. A committee should apply the mind. RP should apply the mind and come to a conclusion whether what would be the value in the event of liquidation. For example, a land, a building of which 60% allotted, few completion done. Look at 30 subsection 31. Then whether you can sell it in a different in a part way, whether you can do construction without the concurrence of other people who've already been staying there. All those things expect you to have a application of mind. Please come back to 30 subsection 4. I'm extremely thrilled to tell you this, friends. 30 subsection 4 is a diamond provision. What is saying? The committee of creditors may approve a resolution plan by a vote of not less than 66% of voting share of the financial creditor after considering the feasibility and viability. It was the only thing I remember. It was 75% when I passed the RP in 2017. So the moment we think about 75, we cross to the next section, because those days there was no books. We used to read all these, bare acts. Friends, till now what is written? The committee of creditors may approve a resolution plan by a vote of not less than 66%. Very simple. Of voting share of the financial creditors after considering its feasibility and viability. But what happens was every case went down for liquidation. So suddenly in 2019, after 3 years, they decided to bring in this. What did they add to third? Look at 2019, with from 16/8/2019. I still remember I was traveling when this notification was bounced at the IBBA website. I was traveling to Hyderabad. I read through this document. The manner. So what do you mean by feasibility and viability? What do you mean by feasibility and viability? Yes, Prashant, I shall come back to you on that. Prashant has asked a question. After this, I'll explain to my knowledge. Okay. Now, friends, look at this, extremely important, friends. Because this is something is going to be of huge relevance. Committee of creditors may approve a resolution by a vote not less than 66% of the voting share of the financial creditor after considering its feasibility and viability. Nobody knew what is feasible. Nobody knew what is viable. All little we know is application of mind, or the committee of creditors decision is final. Commercial wisdom, and commercial wisdom did not come in 2019. It came after that. Now look at this, friends. This is, according to me, the coming paragraph, the ensuing paragraph is the words are the definition. What constitutes feasibility and viability is this: the manner of decision proposed, which may take into account. So the sections 30 subsection 4 says feasibility and viability, comma, the manner of distribution, which may take into account the order of priority among the creditors as laid down under section 53(1), waterfall mechanism, including, now it's very important, read that carefully, including the priority and value of security interest of a secured creditor. Now we say, when it comes to this, and such other requirements may be prescribed by the board, be it as it may. Now, 30 subsection 4 essentially says a plan which has got 66%, it is done, feasible and viable. What leads to feasibility and viability is this: manner of distribution proposed, application of mind. After considering the order of priority 53(1), simple, you know how it is, 53(1), expenses and all those things, and secured, unsecured wages, 24 months and other thing. Including, this is what I would like to emphasize, friends, including the priority, including the value of security interest. Now, please read what is the definition given in the value of security, security interest in section 331 of a secured creditor. So therefore, my humble submission is, if a secured creditor says, look, liquidation, I didn't get the liquidation value, I'm rejecting it, let it go for liquidation, doesn't work. In IBC, it doesn't work. And this complication was put to rest by the noble soul Rohinton Nariman by the word commercial wisdom. You will never, all of us know, you will never see the word commercial wisdom in the book, in the textbook or bare acts. Only in the judgment you get to see commercial wisdom. Catena of judgment talks about commercial, uses the word commercial judgment, commercial wisdom. Even we also, in the courts, we used to make. So therefore, my view is, friends, let me be putting it very simply, very short. When it comes to 30 subsection 4, 66% says, please pass this. They have applied their mind as to the security interest priority of security interest, value of security interest of the secured creditor, no other purpose of the secured creditor. So therefore, now please look into what is happening in Maharashtra Seamless. Maharashtra Seamless. Second, friends. So Maharashtra Seamless says value. This is a valuer's report. We cannot interfere. That is what Honorable Supreme Court says. Now, this has got huge ramification, friends. This was misused by everyone. This was misused by in Ruji Soya case. It is there in the High Court now. I mean, Supreme Court now. All those things, whether value in the event of liquidation, descending 30 subsection 2B, how it is going to have an impact. All those things are before Honorable Supreme Court. Now I'll tell you this case. I'll take 2 minutes, otherwise it will go on. So what is the learning so far? Don't get carried away by liquidation value. Liquidation value is a value, my friend Prashant asked. Liquidation value is a value which, according to the RV, that value which you can reasonably expect to get if the asset is getting liquidated now. Fair value is a value consenting two persons are coming to a conclusion, coming to an agreement or the value. That is a fair value. And how do they come to a conclusion? Based on certain statutory, statutory notification can also be relied upon. So that is it, Prashant Bhai. Another thing, coming back to most important, why I said Maharashtra Seamless Limited has been totally misused is in one case. Dr. Vijay Radhakrishnan was Bijoy Pulpra. I appeared for Dr. Vijay Radhakrishnan. It's a classic case. Friends, commercial wisdom, 67 or 80, 70% or 80% decided to go ahead with the plan. File comes to me. I just go through the, flip through the valuation statement. I got the shock of my life. I don't think I will ever get a shock in my life like that. The shock was this. There were two valuers. One valuer is from Gujarat. Another valuer is from state of Kerala. The Gujarat valuer says he has taken these things, assumptions. And in that valuation statement, the name of the company was wrong. The assets of the company was wrong. He was saying that the asset is pledged to the state government in Gujarat. That absolutely the wrong. It is just a copy paste or something like that. I don't know. Name was wrong. Assets were wrong. Value was wrong. Still, among say 2-3 assets, only one asset was right. And because of which there was a gap of 15.6. I argued vehemently, saying that 15.62% is the difference. More than that, please go through the experts valuers document. It is not, it's saying that my asset is, the asset of the company has been pledged with government. It's not like that. You know what happened? This case was referred and Honorable NCLAT said it is just an estimate. So Maharashtra Seamless, I'm actually arguing for NCLAT Delhi coming on 15. I'm going to use this particular section, but I'm not sure whether I will benefit out of this. But then, fact of the matter is this is being misused. Misused in such an extent that the valuer, he himself, the assumption itself is wrong. Only one asset is taken. Some copy-paste mistake. It could be a copy-paste mistake. Nobody has put their mind just before releasing to the person. At least we should look into that, no? That was not done. All right, I'll quickly move to the next one. GL Sultania and others versus Security Exchange Board of India. So this is about taking over of a company with 7.3% of the shares was given by one of the person to another person, so that the other person get a substantial in and of the 7.3% in the target company. So what was the issue? Issue was Regulation 20 subsection 5 of the Takeover Code of the SEBI. Here also, friends, what has happened was multiple, nobody is a Mr. that Somani is not agreeing to the valuation of one valuer. So board took a lot of value, a view, took the service of an expert, merchant bankers took. So 40 rupees, 40.02 rupees, then SEBI intervened, another value of 64 rupees. Acquirer still was unhappy. So SEBI allowed appointing another fresh valuer. So 60.04, look at this, 40, 43, 64, 60. SEBI held that the highest price per share among the three valuation be the fair price, which merchant bankers agreed. Appeal filed by the appellate tribunal, and it may be further noted that appellant GL Sultania had complained against the valuation of shares by the merchant banker. And while doing so, he had enclosed copies of two valuation reports. Where he has also done certain other things, valuing the shares of the target company as much, much, much higher, 408 rupees and 590 rupees. Appellate tribunal did not accept the valuation reports of the produced by the appellant, which valued the shares abnormally high rates. So board appointed certain people, merchant bankers valued, respondent valued, SEBI did the valuation. Suddenly the appellant pops up saying that no, this is all two-digit figure. I'll give you some three-digit figure. So that is it. Appellate tribunal held that SEBI had acted strictly in terms of takeover code and approved the public offer. Valuation of shares as accepted by SEBI was arrived at after following the norms laid down under 2 subsection 5 of the takeover code. So aggrieved by the appellate tribunal, the appellants had filed the instant appeal under section 15Z of the SEBI. First objection was the SEBI as well as the merchant bank had not approved. They had not properly valued the shares. So that was the issues. So what were the issues? Issue said SEBI did not, and as well as the merchant banker did not properly utilize this. I mean, properly appreciate, properly value this. Price approved by the board, that is 40 lakh, that range was not a fair price. That is the second issue. So what did Supreme Court said? Look, the regulation applies to infrequently traded shares of a company and lays down the parameters that must be considered in arriving at the value. So infrequently traded shares, frequently traded shares were looked into differently. But it must be understood that the parameters laid down are by no means exhaustive. So you cannot say that, look, this is it is exhaustive. It is, it by no means exhaustive now. It's written like that. There are many other considered which may be factored into valuation process. That's why I said, friends, the expectation of a valuer is that he should not stick on to the mathematical formula. He should not look into just the factor. He should look into other factors also. The regulation mandates that parameters expressly laid down therein must in all cases be considered by the valuer, since they are basic and essential to the valuation of infrequently traded shares of the company. The valuation report discloses non-consideration of enumerated parameters. Report shall stand vitiated for that reason. This, however, does not prevent the valuer from considering other relevant factors. So Supreme Court says, see, you have said certain things have not been considered, be it as it may. To that extent, it can be vitiated. However, that doesn't mean that valuer from looking into other relevant factors. Look at the way English, the language of English being used by the learned judiciary. Regulation seeks to protect the interest of an investor by ensuring that he gets a fair price for his shares in the target company. So again, they're saying that the regulation is kept for that, a fair price, law, logic, justice, and all those things. The board has to act prudently and within the limits of this jurisdiction, and it cannot object to the fair price offered by the acquirer unless it has reason to suspect. In case of doubt, it may require valuation of shares by an independent merchant banker or a CA. If the valuation determined by the acquirer or his merchant banker agrees with the valuation of the board's value, more or less, then board has no option but to accept it. So court was with the board's value. So allegations, this is a little bit technical. Let me just, so there was a different price earning. There was different NAV. There were different capitalization ratio. There were different value revaluation reserve not taken. P capacity value not to be taken. All those things, I think Supreme Court has taken the support of some learned RV. Otherwise, how can a decision can take all the way? Normally, Supreme Court do not interfere in such matters. They will just, fish away. So what was the ultimate thing? Supreme Court held, unless it is shown, friends, this is extremely important. That's why I've put in red. Unless it is shown to the court that some well-acceptable principle of valuation have been departed, meaning if you followed certain thing and assuming you are able to convince the court that it is departed, or the process have been depart from the normal process without any reason, or that approach adopted is patently erroneous, or that relevant factors have not been considered by the valuer, or that valuation was made on a fundamentally erroneous basis. I'm going to use this in my earlier case. Or that the valuer adopted a demonstrably wrong approach or a fundamental error in going to the root of the matter, the court cannot interfere. Therefore, we are supposed to be very careful. I'm looking from the perspective, I'm saying from submitting from the perspective of the RP and RV. We have to be reasonably careful as to what is the principle, what is the project, what is the reasonable expectation, what is the document saying. All those things, if we are going strictly by that, court will not interfere. They have considered all the factors relevant to Regulation 20 subsection 5 of the Takeover Code and adopted a reasonable approach, which does not call for interference by the court. Court says, look, 20 subsection 5 taken care of by SEBI, we will not interfere. Board committed no error in accepting the report, as valuer has acted in reasonable manner, unless it is shown to the court that some well-acceptable principles of valuation have been departed from without any reason, or that approach adopted is erroneous, court cannot interfere in the valuation report. Hence, the board has exercised its discretion wisely. So, court agreed with the board. That is the story. So, what is the learning for us? Be very careful. Follow the rules. Another case, Renuka Datla versus Solvay Pharmaceutical. We have got another 1 hour time. I'll just quickly finish as best as possible. Petitioner was shareholders of the two pharmaceutical company, Dalfar Limited and renamed as Solvay, and Dalfar Interfran Limited. The dispute was with respect to the transfer of shares of these two pharmaceutical company. Terms of settlements are recorded. Terms contemplate valuation to be done in the intrinsic worth of two companies and value at 4.91% of share in the said two companies held by the petitioner. So the dispute was only regarding the 4.91% shares of the two companies held by the petitioner. That is the only dispute. Valuation has to be completed within a period of 12 weeks. The terms of mutual settlement shall form part of this order. So all those things were. Three methods were adopted: asset-based, earnings-based, market-based. 4.91% of the two companies worked out to 8.24 crores. So the valuer approached assets-based, earning-based, and market-based. The question was issues: control premium not added, few important brands not added, DCF not added. So a person of 4.91% says, look, control premium not added. Person having 4.91% says, control premium not added. Look, few brands of this company, important brands not added. And he says, look, you have looked only from the perspective of asset-based, earning-based, and market-based. Why you have not used DCF? These are the issues. So what was Apex Court's view? Control premium not added, no specific mention in the settlement agreement. It ought to have been there as per terms of it to be kept uppermost. So there was settlement, whatever settlement agreement was there, that has to be the top of the mind recall, or that has to be given most importance. It's nothing talking about control premium. So therefore, settlement agreement will go by that. If settlement agreement is not talking about control premium, be it as it may, we will not interfere. Few important brands not added. Assets as per recorded have been taken in taken, and in this case, it has been considered by valuer. So apparent no error. It says error is ERR. Friends, valuer has considered all the products, all the brands. Still, why do you want to? Why should you expect we to interfere? He has taken. He's an expert. We will not interfere that. DCF not used. It's based on future earning. No record produced. Discrepancies were occurred. Valuer under past, no records produced, discrepancies were observed. Valuer used past earning. Based on past earning, the future project is made, no prejudice cost. So therefore, according to the RV valuer, he has given certain past, he based his approach on the past earnings, and future projections were based on past earnings, naturally so. And the view of RV, we don't apparently see any mistake. So there is no prejudice cost. So friends, this is the concluding part. What did Supreme Court say? The court decided that valuer approached the question of valuation having due regard to the terms of settlement and the standard methods of valuation. So settlement agreement he's looked into and the standard. So he has looked into the fact of the case, factual matters, and also the academic or a professional thing, standards, methods of valuation. So he appreciated what method should be applied, what tools, what method should be applied in this particular case. That has to be the mindset of the registered valuer. The valuation has been considered for all appropriate, from all appropriate angles. So he has applied his mind. Who? RV has applied his mind, looking into the settlement agreement, looking into the 4.91%, looking into the impact of branded products. No case has been made out that any irrelevant material has been taken into account or relevant material has been eschewed from the consideration by the valuer. So nothing has been left out, important has been taken also. The plea that the valuation is vitiated by fundamental cannot but be rejected. It has to be rejected summarily. So therefore, friends, what is the learning for us? Learning of this, look at the assignment, look at the, apply appropriately which method has to be used. Ignore things which you feel it is ignored, document it. Take up things which is extremely important, which anyway has to be taken according to the contents of the assignment. Another case, scheme of amalgamation. Again, friends, scheme of amalgamation, there are a lot of case laws. I just picked up few of them just to, So what were the issues? Issues was, there were about 7, I think. Yeah, 5 issues. Whether the respondent company was guilty of hiding special interest of its directors, Arvind Mafatlal, from the shareholders while circulating the explanatory statement supporting the scheme, and whether thereby voting by equity shareholders were vitiated. So something about Arvind, whether that was hidden so that the decision of the shareholders were vitiated, whether the scheme is unfair, unreasonable to the minority shareholders represented by the appellant, whether the proposed scheme of amalgamation was unfair, amounted to suppression of minority shareholders. This case, multiple things, friends, operation mismanagement, amalgamation, and also valuation things. So I thought I'll just pick it up. Whether separate meetings of minority shareholders represented by them were required to be convened on the basis that the appellant's group represented special class of equity. So whether there is a special class of equity has to be grouped. Whether the exchange ratio of 2 equity shares of MIL for 5 equity of MFL was ex facie unfair and unreasonable to the equity shareholders of MIL, and consequently, the scheme of amalgamation on that account was liable to be rejected. So they were saying 2:5, whether that is fair, unfair, or unreasonable. So that was also put to the Honorable Supreme Court to decide. So what was the decision? On the first thing, the trans company that, typically some special interest of Sri Aravind Mafatlal. I don't know whether any relatives of Mr. Mafatlal is hearing this. I'm sorry, I'm using this word. No, court says no, the requisite statutory majority of votes approving the scheme could not have been adversely affected by the non-mentioning of the pending litigation in the explanatory note Even assuming that the division bench was right in holding out that it was required to be informed to the voters as per the requirement of 393 one earlier act. So whether we should consider an explanatory statement to be an important decision, important content for valuation is a question. Court says, no, that's not required. These are all things. Valuer is an absolute good person to decide on this. Whether the scheme is fair, whether the scheme is unfair, court said, no. It could not be said to be that it will not be said that the majority share of sacrifice the class of interest of appellant minority interest when they voted with overwhelming majority in favor of the scheme. Basically, they have majority. The question is, it cannot be said. Supreme Court said it cannot be said that the majority share will sacrifice the class of interest of the appellant. So appellant was having a class of interest status, whether minority status, whether that is going to be, he said, no, nothing. That presumption is wrong. Third, whether the proposed new scheme was unfair and amounted to suppression of minority. That was decided to say, no such situation ever existed before, both at the time of the scheme of compromise or arrangement was cleared and proposed by the board of director of both the transfer and transferee companies, and also at the stage of when the scheme was put to vote before the meeting of the equity share, forming a common class of. So they say the board of both the companies have applied their mind, taken time and decided. So there is absolutely no question of suppression to the minority. What was the fourth thing? Whether separate meetings of minority represented by the appellant were required to be convened on the basis of that appellant's group represent a special class. So they say that our special class was that categorization of special class was, sacrifice, or we lost that special category because of this amalgamation. That was not considered. But now they say a separate meeting was required, yes or no. Unless a separate and different type of scheme of formula is offered to a subclass or a class of creditors or shareholders, otherwise equally subscribed by a class, no separate meeting of such class is required. So court says there is absolutely no need of any in a subclass of the main class of members or creditors is required. On the facts of the present case, appellant has not been able to make out a case for holding a separate meeting. So they have not produced, according to the learned court, court has said that no, you have not produced certain documents, which essentially means essentially wanted you to be, there should be a separate meeting with the class. Now, fifth issue is extremely important, friends. Whether the exchange ratio of 2 equity shares of MIL for 5 equity shares of MFL was exfacie unfair. 2:5, typical, this is a question whenever it comes to amalgamation. No, that is this company to that company, that ratio is too unfair, unreasonable, harsh and all those things. Typical Tomco HLL case also, this has come up. And consequently, the scheme of amalgamation on that account was liable to be rejected. That was the third issue. So Supreme Court said no. When a scheme was as a whole is examined and found to be advantageous and economically and commercial interest to the economic commercial interest of whom? To the company and the shareholder. Only one or two items implicitly implicatory for deciding the exchange ratio cannot tilt the balance. And so many factors and aspects would enter into exercise. So when you're talking company, which is the best interest of the shareholders and other things, one or two items implicatory for deciding the exchange ratio cannot tilt. So you say that, no, that has not been considered. This has not been considered. That should not be the reason for. Otherwise, Supreme Court applied the wisdom, relied on the valuer. Valuer has considered all those things. And you say, look, 2:5 is good for all the class of people. Therefore, one or two things this way, that way, that's not the reason. Supreme Court finally concluded that once the exchange ratio of shares of the transferee company to be allotted to the shareholder of the transferor company has been worked out by a recognized firm of chartered accountants who are experts in the field of valuation, and if no mistake has been pointed out in said valuation, it is not for the court to substitute its exchange ratio, especially when the same has been accepted without demand by the overwhelming majority of shareholders. Therefore, Supreme Court observed, what did they do? They appointed a respectable chartered accountant firm as valuers, and they have come up with the valuation, and no mistake is observed. And one or two things this way or that way, that is not an issue. If no mistake can be put at the said valuation, then it is not for the court to do. If court starts interfering in all these commercial disputes, then no justice can be imparted. That is the in nutshell. Hindustan Liver, friends. I've got another half an hour more. So Hindustan Liver, it's a merger of HLL and Tomco. Issues was on the share exchange ratio adopted during the merger, yield method, asset value method, market value, all those typical three things which all of us use. Reputed CEOs were involved. Merger scheme was challenged by few shareholders of Tomco. Sorry. Federation of Employees Union of both Tomco and HLL, Customer Action Group, and Consumer Education and Research Center. So basically, employees protested, few shareholders protested, and look at that, Federation of Employees Union of Tomco and HLL, all those things. So basically, exchange ratio. Tata's were not, Tomco were not doing well, whereas HLL was doing really well those days. So Tomco gave that. To put it in a nutshell, the performance was absolutely pathetic in the case of Tomco those days. So what was the issues? Violation of section 393 1A of the 1956 as is not making required. Disclosure is in the explanatory statement. Valuation of shares, exchange ratio is grossly loaded in favor of HL. I said lesser number of, I think more number of, I think 2:20, 15 or something like that. 1:50, I don't remember that. Ignoring the effect of provisions of Monopoly MRTP Act, interest of employees of both the companies were not adequately taken care of. These are the 5 issues. Okay, 3 more. Preferential allotment of shares at less than market price to Unilever is not in public interest. So preferential allotment. So HLL was owned by Unilever and preferential allotment was given to them. So that is not in the public interest. Mala fide on account of existence of quid pro quo between Unilever and Tata Sons. They said that there was a deal between Unilever and Tata Sons. And Valuer's report is not acceptable to the Tomco shareholder as he was director of Tomco, and further, as a valuation of the shares for exchange ratio was determined by combining 3 methods of valuation. So one of the valuer, he himself was a director of Tomco. But I have a fair idea of the name of the person. I don't want to name him. Very, very respectable person, extremely respectable person. So they say, because he is the person who has given report, it is not acceptable to the Tomco shareholders. And further, the valuation of shares for exchange was determined combination. So they say, you're talking about these 3 things, market value, yield, market asset value, and market value method together. So it is not acceptable for us. So what does this Supreme Court decide? Supreme Court said, usual rule is that a share of a going concern must be taken on cotton market price, but in case of amalgamation, a combination of all or some of the methods of valuation may be adopted for the purpose of fixation of exchange ratio of the 2 companies. So normally quoted, if it's a listed company, you use quoted market value. But then when it comes to amalgamation, 3 methods were to be used for fixation of exchange ratio. It was noted that even in such a situation, book value method has been described the most as more of the talking point than a matter of substance. So book value is just a academic thing, talking point, but not of substance. Because why? Because book values could be very, very historical. Now, Valuer was a director of Tomco, HLL, and had no difficulty in accepting the share excess. Valuer was a director of, and so director of a Tomco had no difficulty in accepting the share price fixed by him, even though he was a director of Tomco. Hence, if there was any bias, it would have been in the favor of Tomco and not against Tomco. This is the way it is interpreted. No, there can be challenge for this particular statement, but Supreme Court says, "Arey, Valuer is a director of Tomco, so he should be if at all he is, if at all you say that this thing, then he is the person who has taken decision, so he'll be more aggrieved than any other person. We say you cannot have more concern than a king about his country. A praja cannot have more concern than a king about praja ought not have more concern about the country than which a king have. That is what a typical principle. Just jurisdiction of the court in sanctioning a scheme of merger is not to ascertain with mathematical accuracy if the determination satisfies the arithmetic test. Company Code does not have the exercise appellate jurisdiction. It exercises a jurisdiction founded on fairness. What requires a thoughtful consideration is whether the Company Code has applied its mind to public interest involved in this merger. So, going through the words of this judgment, I am sure that Supreme Court said, look, the lower courts will look only into the fairness. They don't have the expertise, arithmetical. They're not expert in this valuation, arithmetical accuracy, and all those things. Fairness. They look only at fairness. And what requires is thoughtful. What you need to do when it comes to an amalgamation or a merger, what needs to be thought is whether the company has applied the mindful in the public interest involved in the merger. So those days, a lot of employees were working Tomco. There were a lot of employees. And one company, HL, is doing amazingly well. Tomco was deteriorating. So what is the best interest of the company? About 60,000 members. I mean, shareholders were there, employees were there. So it is always better in the best interest of the company. But it is good in the best interest of the company. So what did Supreme Court went on? What is imperative is that such determinants should not have been contrary to the law, and it is not just unfair to the shareholder of the company. So court, when it comes to lower court, they may not be experts in valuation, but they will look into the fairness. They will see whether arithmetical other things are just okay because they are not experts. But fairness, public interest. If that is satisfied, then that is okay. Court's obligation to be satisfied that valuation was in accordance with law and it was carried out by an independent body. So who valued? Respectable chartered accountants. Since 95% of the shareholders who are the best judge of the interest, if 95% of the shareholders who are the best judge of their interest and are better conversant with market trends agreed to the valuation determined, the court declined to interfere. So 95 typical commercial wisdom in 1994, friends. Court said, no, we will not interfere. 95% of the shareholders said this is fine. Independent chartered accountant. Tomco was not doing well. Employees, other important public interests also should be taken care of. Fairness is there. So we will not interfere. Three methods were used. It was held that sales by open public auction or inviting tenders from general public may have fetched more price due to competition, but that could not result in vitiating the determination of valuation. The amalgamation cannot be faulted for this reason. So somebody was saying that, look, if it has gone for an auction, see, whether amalgamation intends an auction? No. Amalgamation merger expects to merge and take the company as a going company, going forward, as a going concern, and ensure that all the stakeholders taken care of, job is preserved, government's duty is there, PF is paid. Topco is such an amazing company, even HLL also those days, even now also. But look into that proposition. Now, you cannot say that you can compare this with selling by an auction. It's not like a market, a piece of art can be sold in the public auction. That's what court said. But that could not result in vitiating the determination of valuation. The amalgamation cannot be faulted for that reason. And the scheme of amalgamation provided that all the staff, workmen, other employees in the service of Tomco immediately preceding shall become the staff of the transferor company. What a noble thought. Look at the cost they have taken, because they were highly paid people. In fact, in Kochi, just near to my office, they had a huge area. They were manufacturing soaps and detergents. I mean, a lot of people were involved. You cannot go through that route if at all in the morning 8 o'clock. A lot of people will come and join all those things, typical of an industry. There were clauses in the scheme of amalgamation that protected the interest of providing that, interest by providing that the terms and conditions of such employees shall not be less favorable, and all benefits as a PF shall stand transferred to HLL. So what happens is those people who are working in Tomco got the same benefits and got transferred to HLL. Of course, I remember a few of my friends who used to work there. HLL, Tata is a very generous people, when it comes to, they are not like a typical MNC. Those days, I don't know about now, but HLL, there was a cultural shift. Certain people left it because they gave some voluntary thing and they availed it and went off. The grievance of the employees that no safeguard has been provided by HLL employees union appeared to be off the mark, as it is interest of the employees of Tomco, which had to be protected. So there's a no typical of a grievance of the employees, Roko, and all those Samaram was there, all this strike was there, and that had nothing to do with amalgamation. What is the fifth issue? Shareholders has no interest in the assets of the company while the company is in existence. It is only at the stage of liquidation of the company that the shareholders became interested in the assets of the company. The share of any member in a company is movable property and transferable, and in the manner provided in the article. So suddenly Supreme Court started being critical here. No, it was nobody thought about the company. Shareholders never thought about the company when it was in existence. When it came to a liquidation and amalgamation, all those things, you certainly thought about it. So no, it's not fair. So merger is extremely good. There was done by, it was done by fair number of people. I mean, chartered accountants and everyone taken care of. Valuation was reasonable. And if at all you say that you are agreed, no, the Domco director himself, then about 95% agreed. So all those things put together, Supreme Court says it's good. What was the sixth issue? Sixth issue was this. Relied upon the judgment of Fertilizer Corporation Kamnagar Union versus Unifinda, wherein it is held that it is not a part of judicial process. Friends, this is very, extremely important. That's why I pasted it. It's not a part of judicial process to examine the entrepreneur activities to ferret the flaws. The court is least equipped for such oversights. Look at the way it is written. Judiciary will not not look into the management or entrepreneur activity. Very clear. Nor indeed it is a function of the judges in a constitutional scheme. So the court should not go and look whether that company is managed well, that scheme is good. No, that's not judges this thing. Probably at best they can take the help of an expert or an amicus curiae or whatever. Now, merely because the scheme envisaged allotment of 51 equity shares, person equity shares of the Unilever, the scheme cannot be held to be against public interest. So what was the essence of the scheme? Essence of the scheme was Tomco's 51% was given to preferential Unilever because they had the money. Employees was taken on the roles of HLL, 95% accorded, 3 types of valuation done. I mean, some operational difficulties should not, if at all you raise that as a claim, the judiciary is not expected, even in the constitution, to discuss on whether the company has been managed well or then, entrepreneurial activities were done well or not. That is not the Supreme Judiciary's role. That is the typical example. Friends, let me be very fair here. This particular case, I clearly remember, it is an end result of necessity. If at all the judiciary had intervened in this particular thing, it would have become a precedence and rightfully done by Honorable Court. This is with regard to the income tax case. I'll quickly take a couple of cases more. Assessment order was initiated and the total income, this is typical 56 case that the premium and all those things, valuation, remember when it issued at premium, huge premium, company was doing miserably bad. So that is the case here. Assessment order was issued under section 143(3), first assessment. And the total income of the company was assessed 90,95,000, 46,200. Finding of the assessing officer were as follows. No effort was made by the assessee for achieving the projection made in the valuation report as per 11 UA of the Act. So assessing officer start talking about valuation methodology under the Act. Assessing company had invested share capital and share premium received during the year in 0% debentures of associate company. So there was an associate company on a 0% interest debentures. Assessee company has invested in the share capital and share premium. They say share capital with a huge premium they invested in 0% debentures of an associate company. Hence, the projection made to the issue of shares on premium as per report is not justified. So that is the crux of it. Rule 11A report says this is wrong. So issue of shares at premium is not right. The assessee failed to provide any scientific basis for adopting the projections as estimated figure used in valuation. So assessee did not give. That's what AO says. First assessment. Assessee company booked a loss of 71 lakhs 99,000. So 71 got 99 lakhs 40,000. And in P&L for the year 2017 on account of loss of sale of investment in unsecured compulsorily convertible debentures of 100,000 each in Script Stories Media Private Limited. Since the investment was in 0% debentures, there was no scope of any income rather than transaction resulted in loss of 71 crores. So you are investing in a company, 0% debentures, so no income to us. Company made a huge loss. So that is what assessing officer said. Even in 2017-18, assessee company kept raising the share capital on premium and at the same time booked losses on account of sale of 0% debentures. So the order was this. Look at the way, keeping on issue, premium, but then 0% debentures. So no income. Hence, the premium taken by the assessee is not justified. So you are investing in a company with huge premium and that to 0% interest. So therefore, you don't have respondent preferred appeal. CIT upheld the additions made by AO. So assessee went for an appeal. CIT said, no, upheld the additions. No, AO was right. So second appeal at ITAT was allowed in favor of the assessee. So second appeal allowed in, so on the appeal on the order of CIT appeals, ITAT held that assessee was right. And the order of CIT appeal was set aside. Revenue appealed. So therefore, no choice but go to High Court. So revenue appealed against the aforementioned order on the grounds that learned ITAT erred in law on the facts in deleting the addition made under section 56(2)(7)(b) of the income tax, that is premium, deemed. So by ignoring the sound reasoning there and detailed analysis of AO, that cash flow projections considered in the discounted cash flow method by the assessee are nothing but paper plans and that have no relation with the reality. So says discounted cash flow method talks about certain things that is according to AO or the department is nothing but humbug. It is nothing is going to happen. That's what they say. Prerogative of assessee as to how much capital is to be raised based on the long-term and short-term funding requirement for the purpose of running its business. It is the risk factor. It is the risk factor alone that gives the high return to a business, and income tax department, revenue department cannot guide a businessman. So Supreme Court, High Court said, no, department do not have the wherewithal to understand all these things. So second appeal at ITAT was allowed in favor of the assessee and order of CIT appeal was set aside. When valuation is done, it is based on reflection of potential value of business at a particular time and also keeping in mind underlying the factors that may change over a period of time. Thus, value which is relevant today may not be relevant thereafter. In discounted cash flow method, the value is based on estimated future projection, and these projections are based on various factors. So court started saying that, look, determine the business functions, an assessing officer may not have the skill. Section 56(2) of the income tax is not applicable to genuine business transaction, and genuineness of creditworthiness of strategic investors were not doubted by either AO or CIT. So slowly they say that you have picked up certain according to your whims and fancies. In accordance with the subsection explanation, as a respondent assessee had an option to carry out valuation and determine the fair market value only on the discounted method. Shares were issued based on valuation received from the prescribed expert, chartered accountant who use DCF, which is one of the method used in 56(2). So therefore, there is no deviation. They have approached a chartered accountant. company, the valuation is not just what is going to do with the money. Projections can be anything which the department may not be knowing. So second appeal of the ITAT was allowed in favor. So what was assessing? I mean, Delhi High Court said Section 56(2) of the aforesaid act is a deeming provision. Friends, very important. Section 56(2)(7)(b) is a deeming provision, and one cannot expand the meaning of the scope of any word while interpreting such deeming provision. So when it comes to deemed provision, you cannot just interpret all those things, provision, projection, discount, all those things you cannot take. It's a deeming provision. There has to be some enabling provision under rule or the act where assessee has been given a power to tinker with the valuation report obtained by an independent valuer as per qualification given in the rule 11(2) of the 6th income tax rules. So 56(2) talks about premium, and that is a deeming provision. It is deemed to be the premium, deemed to be the income. So therefore, if it is based on valuation report by a respectable chartered accountant or valuer, then the assessing officer cannot tinker and say, no, that valuation report is wrong. No. So deeming provision is very clear. If it is premium, income. Rule 11(a)(2) of the said rules does not give any power assessor to examine or substitute his own value in place of the value determined, or requires any satisfaction of on the part of the assessing officer to tinker with such valuation. The shares have not been subscribed by any sister concern or closely led, but by outside investors who are on one of the top investors and the businessmen of the country. And if they have seen certain potential or accepted this valuation, then how AO or learned CIT appeal can question. So who purchased this asset? An outside person, not a closely related person or a sister concern, an outside person. Outside investor, if they have invested in a company, naturally they would look into all these things. It is a commercial wisdom. So therefore, how can AO and CIT appeal say that no, there is a problem there? So that is something very, very interesting. And decision by High Court of Delhi, DCF methodology adopted by the respondent is a well-recognized and well-accepted method. The approach of revenue that the performance did not match the projection lacks material foundation is irrational. So this is overactivism by the department. Appellant revenue is unable to show the assessee adopted a demonstrably wrong approach, or that the method of valuation was made on a wholly erroneous basis, or that it is committed a mistake which goes to the root of the valuation. They were not able to show. So there was apparently no mistakes. Valuation is intrinsically based on the projection, which can be affected by various factors. We cannot lose sight of the fact that the valuer makes forecast or approximation based on potential value of business. So application of mind was there from the side of RV. However, underlying facts and assumptions can undergo change over a period of time. Absolutely, no doubt on that. So therefore, what did they say? Courts have repeatedly held that valuation is not an exact science, therefore cannot be done with arithmetic precision. It is a technical and complex problem which can be appropriately left to the considered wisdom of experts in the field of accountancy, having regard to the imponderables which enter the process of valuation of shares. So we will not dwell into areas of experts. We are not experts. I mean, we will leave it that. The shares have not been subscribed by any sister, but then by an independent person or a outside investor. If they have been certain potential or accepted valuation, then appellant cannot question. So that is what the appeal was dismissed and the order of was upheld. Friends, this is something which is extremely important. I know this is a typical landmark case, Cushman and Wakefield case. They were the doyens in this business. They were doyens in their business. So business of valuation and real estate thing. So when this valuation came into force, what was Rule 3.2 says? No proprietor partnership entry or a company shall be eligible to be a registered valuer if there's a condition, if So partnership and company shall be, not shall be, shall not be, sorry, the registered valuer if it has been set up by the objects other than rendering professional or financial services, including valuation of services, and that in the case of a company, it's a subsidiary, joint venture, or a subsidiary, or another company, or a body corporate. So it says, no partnership entity or a company shall be eligible for registered valuer if they have set up for an object other than professional or financial services, including valuation. So you have to see the partnership object clause, and if it is for other than professional or financial services, including valuation services, and that in the case of a company, they cannot become a registered value. So they were Cushman and Wakefield is such a big company, multinational company, and they objected. They said, no, petitioner held that it is an over the years instrumental. In fact, we were the person who have started doing, setting benchmark for this entire valuation thing. No, you cannot do like that. We are this, we are that. We have done big projects. We have done all the typical this thing. Further, petitioner invested time, money, and experience in creating a pool of resources. So they had experience in each and every vertical: oil and exploration, real estate, data center, technology, manufacturing, everything. So we've spent a lot of people, a lot of them are on roll. I mean, something has to be done. Subsidiaries or joint ventures or associate foreign in income will continue to import more professionally. So they were spread across all the continents other than Antarctica, and let's go to add value. They said 240 of the companies had impaired the right of the petitioner to carry on the Section 9, Article 19, 1G, Article 14, equality. So petitions not only discriminated against individuals and partnership entities, but also such companies which are not subsidiaries, joint ventures, or associates of other companies. So they say there is an apparent violation of fundamental rights under 19(1)(g) and also 14. So what did Union of India say? Look, Rule 13 of the registered valuer clearly stipulates that the conduct of valuation under any law other than Companies Act shall not be affected. So as on Rule 13, it is mandatory only for companies. And of course, now it's in IBC. So you can go ahead and do in all those, I gently take you to the first presentation for a few slides which I've shown. You still have business there. So where is the question of violating the fundamentals? Go do business there. That is the first time. That's the first point. Valuers had been adopting divergent methodologies, resulting in vast difference in their conclusions. Due to divergent valuation outcomes and criteria, asset valuation in India was not considered credibly. Credible valuation of asset is critical to the efficient working of the financial market. Till the commencement of the Act and rules, there had not been any generally accepted and uniform standards in asset valuation system in India. So absolute subjectivity was part of the entire thing in India. Therefore, we need to put up a system. We need to bring up certain valuation standards. This is the start of, and is the beginning of a big, expansion of credible valuation. That's what they're using. Union of India went ahead and said it is in order to regulate valuation profession under the regulatory regime and to guide and develop the same. Parliament decided to bring in uniformly accepted norms and generally accepted global valuation practices in India by incorporating a chapter in the Companies Act and to set regulatory. So they were taking it dogmatically, principle based. You have to bring the best practice across the globe and bring it to India. See, friends, look at what is happening. So I would say the first point is, if at all you have money, you need not dance to the tune of anyone. If you don't have money, then you have to bring in investors. If you're going to bring investors, they are no-nonsense people. I mean, being very brute, blunt here. They will look into whether this is correct valuation, what is the exit route, what is the best value which you can get after 5 years or 3 years or whatever. So that is simple as that. They are saying without saying all these things. Given the importance of valuation in the fairness of business transaction, every effort has been made by the respondents to avoid situation to conflict the interest with an entity conducting the valuation. So independence. The endeavor of the rules is to introduce a class of professionals where focus is on the professional skills and individuals rather than business ventures. So it is not like indirectly saying that Cushman was looking into as a business perspective, but this is a professional exercise to be taken. There is a rational nexus to the object of disqualifying all entities with interest in other professions or business or enterprise so that the integrity of profession be maintained and there is no conflict of interest. Hence, the rules do not suffer from the view bias of the excessive delegation. So union says, look, if everybody is, or if anybody is allowed having multiple interests, I've got real estate development interest and also service, valuation, then it doesn't gel well. Probably there will be an independence, some sort of independence is required. Therefore, Cushman at that point of time was all clubbed together. It was not independent. Therefore, we need some sort of fairness, we need some sort of objectivity, we need some sort of integrity, independence. So therefore, there is clear classification, a clear reason why we want these people to be independent, and because it's a professional service. If a registered value company is a subsidiary, the joint venture or associate of another company, the said entity may not be able to stand out the independent professional body. May not be. Not saying shall not. It's not that everyone will be like that. But then they say, if they have multiple business interests, they may lack independence. So that is the reason. Hence, if valuation is allowed to be undertaken as a business by such entities, the independence and credibility cannot be ensured. So according to the union, according to the executive, according to the government, they said, no, if it is clubbed together, may be an issue later on. So what was the decision? Objective and intention behind laying down the impugned rule is clearly to introduce the higher standards of professionalism in valuation industry, specifically in relation to the valuation undertaken for the purpose of Companies Act and IBC. The impugned rule obviates the possibility of conflict of interest on account of divergent interest of constituent associate companies, which resultantly shall undermine the very process of valuation, being one of the most essential elements of proceeding differentiality. Therefore, multiple interested, same company, associate company, all those things you may say, but independence and professionalism and objectivity is what prevails, at least in companies that were IBC. The court also relied on the judgment of Supreme Court in Haniraj L. Chulani and held that the exclusion of subsidiary company, joint venture, or an associate or other company for the purpose of eligibility of registration as a valuer is reasonable. So if time permits, friends, please go through Haniraj L. Chulani case wherein court said that it is reasonable that the exclusion of subsidiary company, joint venture, and other thing as a valuer. Exclude, you exclude that and bring it as a simple one. Yeah. Friends, I think we will subject to the confirmation. I've got about 5. Yeah. One more case law we'll quickly go through, friends. So this is an IT-80 matter. Again, it's an IT-80 matter, 5627B, same thing which we have mentioned before. Well-settled law that the statute must take from the bare words of act. One should not look at what could have been in the intention of legislator behind this legislation section. And if a legislator did intend in this way, then it has to be expressed clearly in the language section. So 56 deeming provision, we were just mentioned about this. This is the same thing. In case AO is not satisfied with any of the parameters adopted in the estimating the value, then subject value of the material being available on record, learned AO can adopt his own valuation in DCF or get it valued by some different valuer. So that is the logic. And it was appealed at IT-80, and IT-80 is, decided. At the time when valuation is made, it is based on reflection on the potential value of business. So timing is very important. Time at which this was done is also important. And also keeping in mind underlying factors that may change over the period of time, and thus the value which is relevant today may not be relevant after some time. DCF method, the information to be considered should be on the date of valuation. So, friends, here what happens is AO has erred in comparing estimated projection with actual audited revenue. And this has issued in the tribunal in the innovative case. See, innovative case. So what happens is AO has the judicial or has the provision, legal sanction, legal authority to DCF. But then again, he started comparing lower authority. So here what happened was IT80 was little critical about, lower AOs and CIT and all this. Lower others have not properly adjudicated upon the contentions raised by the appellant. Appellant narrated the reason. So when they came out with the valuation report, they said these are the reasons which the tribunal, which the AO and CIT did not agree. What did they say? They said appellant narrated the reason for variation in the estimated projection in valuation report and 2013 and 14. So it is not just like they just give their reason. Look, these are the reasons for that. The application of mind was there. It was also submitted by the appellant that the estimated projection as per valuation report 3014 are within the range 4 to 6% of the actual audited revenues, and therefore there is no material weight. So there was said audited revenue. My projection was just 3 to 4 to 5%. Sorry, yeah, 4 to 6% variance with the projection. That is not a material thing. Rightly so. Appellant further elaborated that it has considered a growth of 25%, 25% of the total transaction value of reservations to be handled by it and not on revenues. And that corresponding growth of revenue as per the first and second valuation were in the range of 16 to 25% and 14 to 25%, which is reasonable as per the independent search conducted by the AO. So Yatra Online said, look, we have considered only 25% growth. But you yourself has said 16 to 25% or 14 to 25%. So what is the problem in that? So Commissioner Appeal has a laconic manner upheld. Typically, Commissioner of Income Tax appeals will just, casually take it. Upheld the addition made without considering the above factual issues. There are crucial factual issues which have to be considered by the authorities below, and in terms of definite finding being expressed in this regard, it is equal for all to render a definite final conclusion. So there is a one-liner of this thing. Let me quickly, I'll just quickly, we'll take Ankit Mittal's case. NCLT or case, but a small shareholder objects, RD also. Friends, this is an area. Now, this is extremely important, friends. I'll take only 2 minutes for this. So far, we were speaking about court do not interfering in valuation of experts and other things, provided law are correct. Everything has been followed. But look at this, friends. Ankit Mittal case. Let it be, remembered, reminded, alerted by you whenever you take up some assignments. So it was an amalgamation case where NCLT okays, but a small shareholder objects. RD, regional director Chennai also said, no, there is something fishy here. So NCLAT decides the respondent has not raised the issue with regard to alleged power of attorney holder before the learned tribunal. Therefore, this issue cannot be taken up for the first time in appeal. So what is the law? Whatever you have appealed in this thing can only be considered in the lower judiciary, can only be considered. And you cannot extend your appeal. You cannot extend your pleadings at the appeal stage. The swap ratio inter se second respondent and the non-respondent are proposed in the scheme as erroneous and face of it as the second respondent is a promoter of Dalmia Bar at 21.82%. Dalmia is a listed company and net worth of 50 billion. So regional director also, but swap ratio is also good. There is a logic between, one is a listed company, other is, so 50 billion valuation. So therefore, swap is reasonably okay. Regional director also, they say that the swap ratio is little erroneous because of it as the second is a promoter of Dalmia with 21.82% and Dalmia Bharat is a listed company. So therefore, they say the presumptions taken by the valuer swap ratio is not correct because it's a 50 billion company, and the ratio cannot be there is a it should be sailing through with that or sync with that. In this case, it was not sync. The regional director of Chennai has also raised concern about the merit of the scheme. He was also raising issues. A very cavalier approach have been approached by respondents, which is unprofessional, devoid of due diligence expected of them. So therefore, there was some sort of negligence, there's some sort of casualness, there's some sort of irregularities observed by the coach. In view of other reasons as recorded above, and the basis of the valuation report, amalgamation cannot be termed as fair to stakeholders. Accordingly, the impugned order dated 2018 April 12th was quashed and set aside, and respondent was charged 10 lakh rupees. So friends, look at the way we were talking about only supporting the valuer, and in judiciary do not indulging in that. But in this case, Ankit Mittal case, they have looked into the judiciary looked into the RD's views. RD says something fishy, and 21.82% of a 50 billion company, swap ratio difficult, and some sort of wrong was observed. Yeah, I just missed out this. So objection. So basically, the swap ratio was not properly appreciated, and NCLAT also set aside. No, that's not right. So thanks to these organizations, and there we are. I don't know whether I think it's 10:43. We started 5 minutes late.
No issue, sir. On behalf of Bangalore Valuer Association, I express my sincere thanks to you. And I could see the lot of pains in in collating a lot of data actually. And as you rightly said, generally the courts are in favor. They don't interfere into the rather the commercial wisdom of valuers. But then in the case of Ankit Mittal, it has gone the other way around actually. It's a very new thing to most of us actually. The court can also take a view on this. So we all need to be extremely careful, and as a valuer, how we do the justification of our valuation has to be proper actually. I mean,
And 10 lakhs fine also. 10 lakhs fine also. Yeah,
fine.
10 lakh crashing plus 10 lakhs fine. Be careful.
10 lakh fine also, exactly. So we need to be careful actually.
And 1 second, there somebody was asking, they have not, it's Pankaj Agarwal, somebody was saying that he has not got the money. Assuming Mr. Pankaj is here, I suggest that you should definitely appear before, file an IA before NCLT, keeping the COC and the RP as a person. Definitely, if it's a CIRP cost or liquidation cost, you will get it. There are enough and more judgments even in NCLT Kochi also. Concurrent judges, concurrent benches used to look at as a guidance, not as a persuasive thing. So that is my view on that. Yeah, yes, sir. I'm sorry.
Yes, sir. Yes, sir. Actually, it's eye opener to all of us actually. How we need to be careful, despite all this thing. Actually, we also tend to miss a lot. Sir, as a token of our love and affection, we share this moment. I'm just is there, and we sincerely thank you for all the efforts you have taken actually to present a wonderful presentation to us actually. So we will send it by courier to you, sir.
All right, anytime. Thank you. Deeply appreciate.
Thank you so much, sir. Once again, actually, thank you, sir. Thank you.
Can I log off? Thank you.
Thank you, sir.
Thank you. Thank you.
Thank you.